Hello and welcome back to another video on the OCR law specification. Today we're going to be looking at private nuisance. Private nuisance is a common law tort, and on this slide you can see the test, the three-part test that you'd need to go through in a scenario. The first part of the test is the question as to whether the claimant has a legal right to bring a claim. So the first thing you need to do is essentially in this part of the test is establish who's the claimant and who's the defendant. The claimant has to have a legal right to bring the claim. We'll explore what that means in a second. And you need to establish why the defendant is an appropriate defendant to be able to be sued in that instance. The second part of the test is you have to establish what the interference was, and that can either be physical damage or a loss of immunity. Again, we'll explore that in a second. And then finally, the third part of the test is you have to explore whether the interference was unlawful by reason of it being unreasonable. And there's 6 factors to consider there. So in terms of legal rights, the first part of the test, establishing who the claimant is and who the defendant is, the claimant must have a legal interest in the land to be able to bring a claim under private nuisance. So they have to either be an owner or renting a property. They have to have a legal interest. The classic case is Hunter v Canary Wharf, and in this class action there was a number of people suing for what was happening. It was a building site basically, and there were lots of interferences, noise, dust, interference of TV reception, those sort of things. In one particular case within this one, claim within this case, a couple was suing essentially, and the wife couldn't sue because she didn't have a legal interest in the property. Her husband owned the property. She had no legal interest in it, so therefore she was unable to sue in that instance for private nuisance. That's usually fairly simple, so you need to watch out for questions and make sure that the person you're looking at does have a legal interest. That's the first thing you need to establish to be able to decide whether actually can they bring a claim in private nuisance. The second thing you need to establish within this first part of the test is who is the defendant. Now, the defendant is usually the person making the nuisance. In most cases, that's the easy sort of solution. But it can be someone that becomes responsible for the nuisance on their land, even if they didn't make the nuisance or start the nuisance. And equally, landlords can be responsible for the nuisance created by tenants. So in Sedley Denfield v O'Callaghan, the defendant owned a piece of land. The council came in and installed a pipe without his permission. He didn't challenge it, didn't do anything about it. A couple of years later it flooded. He was then held to be liable for it, for the nuisance that it was causing, even though he didn't actually make the nuisance. He became responsible for it by not doing anything about it, essentially. Equally, in Tetley v Chitty, the landlord who'd rented out some land as a go-kart track was responsible for the nuisance created by the people that were running the go-kart track, which was creating noise, etc. The second part of the test is there has to be an interference. The interference has to happen frequently, often described as continuous. Generally, although there is an exception we'll come to a bit later on that, but generally it's got to happen continuously. It can't just be a one-off, generally. It also has to be indirect, so it has to be something that the defendant themselves aren't going onto your land and causing physical damage. It's something indirectly happening. So often things like noise or smell or vibrations and things like that is what can be done indirectly. There are 2 types of interferences you can look out for in a scenario. The first one is physical damage, which is the actual physical damage, which is often caused through, like we said, things through like vibrations and things like that. Holbeck Hotel v Scarborough was to do with a landslide. The best case to illustrate this is St Helens Smelting v Tipping, which is at the bottom of the page there, which established that damage was more likely to be nuisance than loss of immunity because it's more quantifiable. You can demonstrate that there's been clearly a nuisance because there's physical damage in the instance. So that's more likely, and that's something worth saying in your answer, that physical damage is more likely to be nuisance than loss of immunity. Loss of immunity is to do with the enjoyment of your land. You're not enjoying your land as much as you could have or should be able to. So these are things like noise, smell, things like that. The good case on here is a case called De Keyser's Royal Hotel v Spicer Bros, which was largely to do with noise being the loss of immunity and therefore impacting people's sleep and things like that. Once you've established the interference, you then need to establish whether that interference is unlawful or not. And actually, they don't use the phrase unlawful. What they look at is whether it was unreasonable. So you'd say, is it unlawful by reason of it being unreasonable? It's got to be so unreasonable that the claimant isn't essentially expected to put up with it. The court will consider multiple factors, so your job in a scenario is to identify which factors are relevant. It certainly probably won't be all 6, so you've got to establish which one you want to talk about and then explain why they're relevant and how the court would balance them and what result they come to by looking at them all. The first one is sensitivity, so this is to do with whether the defendant has something whether the claimant has something particularly sensitive on the land. The case of this is McKinnon v Walker. In McKinnon v Walker, the defendant had some rare orchids as well as some other plants, and the defendant caused damage to these orchids as well as the other plants. Now in that case, because the other plants were affected as well as the rare sensitive orchids, he was able to sue. However, if his sensitive orchids had just been damaged but no other plants would have been, then he wouldn't have been able to sue. So sensitivity basically decreases your likelihood of being able to sue for nuisance if you've got something that's sensitive and only that is affected. So what you've got to watch out for in scenarios is where only something sensitive is being affected, in which case it's less likely that would be unreasonable or unlawful interference. In terms of locality, in the case of Sturgis v Bridgman, the judge made a reference to the difference between sort of urban and rural and what you can expect in those different places. So in an urban landscape, you may see things like more lorries, traffic, factories, things like that, more noise at night, nightclubs, those sorts of things. Whereas in the rural area, you wouldn't see any of that, but you may have things like tractors or barnyard noises, so like animals of like chickens and sheep and things like that have that noise, which you wouldn't expect equally in the city. So locality is a really big thing, and then even within the city you could think about the difference between residential and industrial areas, and again the judge would balance those things up as to what was expected in that area and the impact that was having. In terms of duration can be looked at 2 things in terms of how long it's going on for, but also what time of the day. Obviously things at night in a residential area are going to have more impact, so that's something to consider. Bolton v Stone was to do with the cricket club. A ball was hit outside of the sort of area about 6 times in 30 years. So it was very rare that this happened. So they said it couldn't be a nuisance in that case. It was just not happening enough to become a nuisance of this ball being hit out of the field, the cricket pitch. Equally, in Kimbolton v Crown River Cruises, this is the exception because in this case a firework once landed on a big barge and set fire and destroyed the barge. So it was a one-off, which normally, as we said previously, nuisance has to be a continuous thing, but actually in this case, because so significant damage was caused, they were allowed to sue for nuisance even though it was a one-off situation. So you want to watch out for situations like that where it was one-off but actually significant damage was caused, and then you want to use Kimbolton v Crown River Cruises as your precedent to back that up. Malice, if something is done with bad intentions, so they're doing it on purpose, then it's more likely to be a nuisance. So in Christie v Davey, the 2 neighbours were having a dispute because one was running singing or piano lessons and the other neighbour didn't like that, so he'd bang on the walls and shriek, and that was done with bad malice, so therefore what he was doing was claimed to be a nuisance, and it was successfully claimed to be a nuisance. Equally in Emmett v Hollywood Silver Fox Farm, a man went round near this farm and fired a shotgun into the air, which caused the silver foxes to miscarry, and that's obviously hit the farmer's profits and things like that. So because he was doing it on purpose with malice, it was held to be unreasonable. So again, that's a really easy one to watch out for in scenarios. In terms of social utility, this is the benefit to society. What use does it have to society? So that could be things like job creation. It could be something for the community. So Bolton v Stone, the cricket club, was held to have a social utility to some extent in terms of it was providing a recreational area and exercise for people to get together as a community. In the case of Dennis v MOD, a man, or the claimant in this case, was suing because there was a flyover of RAF jets doing training missions essentially over his house, which caused significant disruption. The problem with this is, of course, is you need them to do that for national security. So there was a clear social utility, social use to them doing that. So therefore, he wasn't successful per se in claiming that it was unreasonable. Although, interestingly, we'll come back to this case later, because although he wasn't able to get an injunction to stop it, he was awarded damages, and we'll come back to as to why later. In terms of planning permission is not a defence. What comes under defences later, but it's not a defence. It's just a factor that the court will consider. So just because the defendant has planning permission for whatever they've done doesn't necessarily mean that it won't still be considered to be a nuisance. So it's just something to consider, although it's more likely if they've got planning permission that it won't be a nuisance. So it's just another factor to consider, and that was considered in that case of Wheeler v J.J. Saunders. You should also consider defences when looking at nuisance. There's 4 defences that you could look at. Valenti is where you can basically say, the defendant basically says to the claimant, well, you knew I was doing this and you moved next to me. That defence has never ever been successful, but it is still worth mentioning in a scenario if it's relevant. So if it mentions something in a scenario about someone moving next to the nuisance, or they bought a house near it or near something, you certainly want to mention it in your question, but make sure you say that it's never been successful. So you shouldn't say that it would be successful in your answer, because clearly it wouldn't be. And remember, Valenti means consent. Prescription. Prescription is a defence that basically says you've been doing the nuisance for 20 plus years, so therefore you have the right to continue doing it. That generally should be quite clear in a scenario, because it would have to indicate that it's been going on for an amount of time. The key thing to remember with this one, though, is the 20-year period starts only when someone could have been affected by the nuisance. So if you have a church with church bells that have been ringing for 400 years, if no one was ever affected by that nuisance, and then suddenly they build an apartment complex next to it, the 20 years starts when they build the apartment complex. So actually, if someone then complains of nuisance there, they could silence the bells. So it's really important that you make sure that there was, someone could have sued in that 20-year period. If there was and they didn't, then therefore the defendant has the right to continue doing that. And that's the case Sturgis v Bridgham, which is the main case on that, about building a sort of doctor's surgery room at the end of Doctor's Garden, which was being disrupted by a factory at the other side on the other of the land boundary. Statutory authority is where the defence is the defendant has the statutory authority, so authority from a statute, from law, parliamentary permission to do it. That was a case of Allen v Gulf Oil. So again, that would be very specific in a scenario. They'd have to mention that there was a particularly statutory authority. And finally, as I said, planning permission is not generally seen as a full defence. It's only a factor, as we mentioned on the last slide. Finally, in terms of remedies, there are 2 remedies you might be looking for in these sort of scenarios: damages for quantifiable damage or loss of amenity. So damages for what basically the damage that's actually been done, or the loss of amenity, the loss of enjoyment you're having in land, which is slightly harder to quantify, in fact, or to calculate an actual price for that. As we saw that in Dennis v MOD, they were awarded, as I mentioned earlier, damages. The other thing you might want is an injunction, either a prohibitory, which is stopping you doing something, or a mandatory injunction, which means doing something. So the classic example is stop playing the drums or soundproof your room. Those 2 versions to stop the nuisance. And the classic case you want to mention when you're talking about an injunction is Miller v Jackson, which involved an injunction in that case. Hope you found that useful. Please don't forget to like, comment and subscribe, and thank you very much for listening.